Good afternoon. My name is James Ratchford, and I'm an attorney practicing Social Security disability advocacy. I help my clients get benefits from the Social Security Administration through the programs of SSD and SSI. Today I want to talk to you as briefly as possible about the 5-step sequential evaluation process. This is the actual legal evaluation that has to happen in a disability determination decision, whether that's by the lower level, what we call DDS, Disability Determination Service, which is a state agency, or by a Social Security Administrative Law judge when addressing a final decision after a hearing. Either way, we're going through this law. It's 20 CFR 404-1520, 416-920, which lays out what questions have to be answered in a Social Security decision. So it's 5 steps. The first of the 5 steps is the person performing substantial gainful activity? In other words, is the person working? Now that's a dollar threshold. If you're working either full-time or earning over a certain dollar amount per month, which is about $1,200 in the year 2020, then that person cannot be found disabled no matter what's going on medically. They could be completely wrecked in terms of their physical and mental health, but if they're working and earning more than $1,200 a month, they cannot qualify for Social Security disability benefits no matter what. The next question, step 2, is does the person have what is called a severe impairment? A severe impairment is going to be a specific documented medical condition that has some limitations imposed on the person's ability to work. This is going to be any medical condition that in any way affects your ability to work. And the question at step 2 is merely whether a condition exists and what the condition is, and it simply has to be any condition that imposes some degree of limitation on your functioning. Now, step 3 is the first step at which a person can be found disabled, and that is called the medical listings. The medical listings is a guidebook. We sometimes call it the Blue Book. It is an appendix of the Social Security law, which contains a list or listing of various medical conditions and specific medical criteria that go with those conditions in order for a person to be found disabled. These are very clear-cut cases where a person tends to be pretty obviously disabled based on their medical condition, and these cases are typically granted at the earlier levels of the application process, but this does come up sometimes in a hearing. A step 3 finding is going to be based on generally a medical expert's evaluation of the file as to whether those specific criteria are met. Now, steps 4 and 5 are where most cases are decided, and both steps rely on something called a residual functional capacity assessment. A residual functional capacity is the legal term for the judge's or adjudicator's finding on what you can and cannot do, what your functional capacity is, your functional capabilities in the work setting. So functional capacities are divided into categories. We've got less than sedentary, sedentary, light, medium, heavy, and very heavy. And those correlate to different levels of weight, lifting, and standing and walking requirements that go along with those levels of work. And generally speaking, a person's functional capacity is going to determine their answer to steps 4 and 5. Now, step 4 is the question, can this person perform their past relevant work? And that means that the government is going to look at their job history over the last 15 years and compare it to their residual functional capacity. And if any of the jobs in the last 15 years match up to the person's residual functional capacity, that is to say, if that person can perform any jobs they've done in the last 15 years, then that step 4 finding is going to be that the person is not disabled, and that's the end of the process. Then we move on to step 5. If the person is not capable of performing any of their past relevant work and gets past step 4, then we go to step 5, where it is the government's burden to prove that a person can perform jobs if the government wants to deny the claim. And if the government cannot come up with jobs that a person can do within their residual functional capacity, then the claim is granted. The question at step 5 is, can you perform other work? Generally speaking, this is going to be whether jobs exist within your residual functional capacity. So whatever limitations are in your residual functional capacity will be compared against the job market, and this is typically done with the help of somebody called a vocational expert, who's basically a job placement counselor for people with disabilities. And that vocational expert will tell the judge whether or not and what jobs exist based on those functional capacity limitations. Now at step 5, we do consider something called the grid rules, which means that if you're over age 50, we don't consider the entire universe of work. We rule out certain jobs that we say, even if he's physically capable of those jobs, we don't expect him to adapt to that kind of work. That applies after age 50, and actually at age 45 for people who are illiterate or unable to speak English. So those are the 5 steps to the sequential evaluation process. Are you able to perform substantial gainful activity at step 1? Do you have a severe impairment at step 2? Does that severe impairment meet a medical listing at step 3? Can you perform your past relevant work at step 4? And can you perform other work at step 5? I'll have other videos going into the details on each of these. And really, step 5 is where most of the analysis happens. But it's important to be prepared for whatever may happen in a hearing at each of these steps. Thank you.